Hello everybody and welcome to today's webinar. This is the 10th webinar in our 15-part webinar series presented by the ENSafrica Banking and Finance Department in conjunction with our ESG Working Practice Group. Thank you very much for joining us. To those of you who are joining us for the first time, and for those who've been with us through this journey, thank you for continuing to log on. This is the second time that we're presenting the CPD webinar series. We did so last year as well. But this year we have a special focus on ESG, and we've been discussing topics that we believe are pertinent for the financial services sector under the heading of the E, the S, and the G. Today's topic is one which I think is very close to many people's hearts and something that a lot of businesses are grappling with from a risk perspective, and that is managing cyber risk. Obviously, we've all seen in the news a few cyber issues and cyber attacks, and our subject matter experts Ira Gunning and Raki Dillop will be speaking to us today about how we can manage these risks better as a matter of governance and how financial institutions can protect themselves against cyber attacks and cyber risk. This, as I said, this webinar is part of a string of webinars. There have been ones that have been presented already under the E and the S, and if you are interested in those, you can log onto our website and have a look at them there. There are also further webinars coming up later this week and in the following week, and please do email marketing@ensafrica.com if you would like an invite to any of those. The webinar is accredited for a CPD hour, one CPD hour, but in order for us to be able to issue a CPD certificate to you, please make sure that you remain on the webinar for the full hour, as we can only issue certificates to people who've been in attendance for the full duration of the webinar. And if you are in attendance, then you'll be able to get a certificate from our marketing team after the webinar is completed. Then you are encouraged to ask questions of our presenters. They would love to answer your questions. You can do that by using the Q&A block at the bottom of your screen. Please don't use the chat block. It's just easier for the presenters if you ask your questions in Q&A. And then at least also if we run out of time and they aren't able to answer your questions, they can get back to you afterwards directly. So without any more from me, please do, I hope you enjoy the webinar, and I'll hand over to our presenters now. Thank you.
Hi, good afternoon, everyone. Thank you for joining us this afternoon. We are very excited to speak to you today. As Jess mentioned, I'm joined by my colleague Ira Gunning, who's an executive in the banking and finance team, and myself, Raki Dillop, who's an executive in the technology, media, and telecoms team in the corporate and commercial department. So today we're going to be talking to you a little bit about cyber risk, cyber governance, POPIA, and the Cybercrimes Act, and how to manage all of that in the context of ESG. So jumping straight into it, we always like to start, any of these kinds of discussions with understanding the definitions of what we're talking about. So as you know, this session is called, managing your cyber risks, and in the context of ESG. And so specifically, what we're always looking to do is to try and understand what exactly is a cyber crime and what are these cyber risks. So funny enough, it's actually a very difficult thing to try and define. In one of the national cybersecurity policy frameworks, which was published in 2012 in South Africa, which was a long time ago, tried to define cybercrime as an illegal act, the commission of which involves the use of information and communication technologies. Now, it doesn't really give us much substance there, and it's really difficult to understand exactly what a cybercrime is just from that definition. All we know is that it's some kind of illegal act, and it involves some kind of tech. And since then, we all intuitively can understand what cybercrime is, but it does become very difficult to define. So our legislators in the Cybercrimes Act actually took the view that not to provide a specific definition for cybercrime, but what they did was created a number of offenses which we can refer to collectively as cybercrimes. So once we understand what a cybercrime is, we can then try and address it and and work on how to mitigate the cyber risks that come from these. Here, it's a bit easier to define what a cyber risk is, and it commonly refers to any risk of financial loss, disruption, or damage to the reputation of an organization resulting from the failure of its information technology systems. And so all of us are trying to actually guard against these cyber risks that come up. Why is, cyber risks so important to mitigate? Why is there such a focus on cybersecurity? And these interesting facts and stats really highlight why it's become so important. So Accenture actually found that South Africa has the third highest number of cybercrime victims worldwide, which costs our country 2.2 billion Rand a year. Now, those stats are staggering, to be the third highest in the world suffering from cybercrime, attacks is massive. South Africa had a 100% increase in mobile banking application fraud. We suffer 577 malware attacks every hour. And South Africa is one of the top 10 countries globally receiving the highest volume of cryptocurrency from illicit addresses. We've also had the highest targeted ransomware and business email compromise attempts. So when you look at these facts and stats, it really does showcase why managing cyber risk becomes so important. Most recently, the International Criminal Police Organization, Interpol, issued their report on, the African Cyber Threat Assessment Report. And this was across the continent. And what they identified was that Africans face these top 5 threats, at an organizational level, at a business level, but we all face these most common cyber threats. The first is online scams, people trying to mimic other addresses, trying to pretend to be someone else to scam you from your money. Digital extortion, this involves, where they might have compromising emails or, any kind of images of you of a personal nature, and they try and extort you for money before you can, so that they do not really release that information. We get business email compromise attacks. These relate to where they intercept the communications between you and your clients, you and your service providers, and they pretend to be that counterpart. And naturally, it involves some kind of payment. And before you know it, you've paid the wrong person. Ransomware attacks, they infiltrate your organization, they take over your systems, and they shut it down. And they prevent you from accessing those systems and your infrastructure unless you pay a sum of money. And then lastly, botnets. And these are basically very sophisticated technology, artificial intelligence tools that actually come into your system and take over. And, also similar to ransomware, there is the threat of releasing information or deleting everything and destroying everything unless you pay a sum of money. So these have been, highlighted as the top 5 threats. More recently and closer to home to everyone is obviously with the COVID pandemic. It became really important for everyone to work from home. Naturally, these gave rise to a lot of cyber risks because everyone was now in cyberspace, connecting over Teams, Zoom, over the internet, over emails, trying to keep in touch over WhatsApp. And so it really gave rise to all of these risks around, Wi-Fi security, hacking, using public spaces, using your own devices, connecting to VPNs. And a lot of vulnerabilities came through because of the use of these systems and infrastructure and technologies that weren't as protected as before. So, during the pandemic, during COVID, it really gave rise to a lot of cyber risks that now many organizations are addressing. I'll hand over next to my colleague, Ira Gunning, to talk through more specific issues around POPIA.
After I unmute myself, I'm going to be discussing the Protection of Personal Information Act. So this is one of my favorite topics, POPI. I still call it POPI. I know most of you probably call it POPIA, POPI, the POPI Act. It's all the same thing. It's our legislation that starts off with privacy and our right to privacy. And very often people think data protection and privacy are boring topics. And I'm going to start off with telling you about the Ashley Madison hack, just to show you that data protection is certainly not boring. And it's also going to link to cyber attacks. Now, I wonder how many people on this webinar today know about Ashley Madison. And I suspect that quite a few people who do know about Ashley Madison may not want to know, they want to admit that they know about Ashley Madison. But Ashley Madison is a dating website with a twist. Their logo or their motto is "Life is short, have an affair." And in 2015, they were hacked by a group of hackers called the Impact Group. And the Impact Group said to them, "We don't like what you're doing. What you're doing is immoral. We want you to shut down." Now, what is quite interesting is when you joined Ashley Madison, they didn't verify, for example, your email address. So I could use Raki's email address and create a catfish profile. They also charged people, I think, something like $1.8 million per year to purge their profiles if you wanted to shut down your profile. But their systems couldn't delete your data. And as you know, in terms of data protection legislation, if you are no longer authorized to have data, you're supposed to be deleting it or de-identifying it. They didn't have systems in place to do that. So they hacked all this data. So the Impact Group hacked Ashley Madison, and Ashley Madison thought it was an empty threat. And the Impact Group said to them, "Unless you shut down, we're going to release the names of all your members and information such as their credit card details, their residential address on the dark net." Ashley Madison didn't shut down, and the Impact Group went ahead and released all that information. This opened a Pandora's box because, for example, 1,200 members were Saudi Arabians. And in Saudi Arabia, adultery is a crime punishable by death. It led to several suicides, including a priest in New Orleans left a note saying he couldn't live with himself after the scandal because he was an Ashley Madison member. Many military members and members of the USA government used their official gov email addresses to sign up for Ashley Madison. And what was quite interesting is Ashley Madison also told people that at least 60% or 70% of the users were female, and that most of the messages sent on the platform were sent by female. It turned out that less than 10% of members were female, and mostly the men were talking to bots when they were interacting with these very charming women. But from a data perspective, of course, we know that you should verify things such as email addresses and make sure that you're dealing with correct information. You should be deleting data when you're not authorized to have it. But what we also learned is when they reverse engineered the passwords, there were two passwords that were used most often than any others. And they were password and 123456. So if you don't learn anything from today's session, if your password is password or 123456, please go and change that immediately. You can also go onto this interesting website, Have I Been Pawned? And you can enter your email address. And then you can see if you've been the target of a cyber attack. And I think about 90% of us on this webinar today have been the target of a cyber attack. But let's get into POPI, why we are here for today. And I'm just going to give you a general overview of the Act. And then I'm going to go through a data breach reporting decision tree that can inform your processes as far as when data breaches should be reported. As I'm sure you know, POPI kicked in on 1 July last year. It's almost POPI's birthday. So POPI is almost a year old today, even though the bill originated in 2008, 2009. POPI applies when we process personal information, which is entered into a record. And as a general rule, this processing must happen in South Africa. And POPI doesn't care whether the company doing the processing, called the responsible party, is domiciled in South Africa or domiciled abroad. We don't care whether the data subjects to whom the information relates, whether these data subjects are South African residents, whether they live overseas, whether they are tourists, whether they're refugees. We care about the fact that personal information is being processed in South Africa, and that information is entered into a record. Now, the processing of personal information is clearly key. Processing, very widely defined, just about anything you can think of with a verb. If I collect information, if I destroy information, if I delete information, if I restrict information, link information, you think it's processing. So absolutely anything you do with data would be seen to be processing. But POPIA applies when that data you are processing is personal information. Now, to turn data or information into personal information, it needs to relate to an identifiable person. Interestingly enough, in terms of POPI, this identifiable person can be a living human being or an existing juristic person, such as a company. Now, I say this is interesting because the overseas legislation that we are based on, the EU directive, and then our sisters around the world that also originated from the EU directive, such as the General Data Protection Regulation in the EU, only protect human being information. We go further. We protect human being and juristic person information. Importantly, we get three categories, broad categories of data in terms of POPI. We get the information that I have left in black font, and that is ordinary information. It includes some pretty sensitive things, such as education, financial, criminal, history, my name, a company symbol, such as a trademark, my views of you, your views of me, and so on. And then we get the red flag information. POPI calls it special personal information. And this information is more protected than your ordinary personal information. And I'll explain in a minute what that means. But this is information to do with your religion, your philosophical beliefs, your trade union membership, biometric information. Criminal behavior, if it goes to the alleged commission of an offense. Remember, your criminal history is just ordinary personal information. Here you've been found guilty already. But where it goes to the alleged commission of an offense, because we are presumed innocent, it's treated with more care. Now, the basic difference between the way POPI treats ordinary personal information and special personal information lies in the fact that for business as usual purposes, it is relatively easy to process ordinary personal information even without consent from the data subject. Consent is a nice to have, but it's not necessary because we can process our ordinary personal information if it's in our legitimate interests, including commercial interests, if it is in the legitimate interests of a third party, legitimate interests of the data subject, if we need it for purposes of our contract, if there's a law such as FICA or the Financial Advisory and Intermediary Services Act phase that tells us we should process this information. So quite easy to find a justification to process ordinary personal information. But when it comes to our red flag information, the tables turn, and it's far more difficult to find a justification to process these types of information without consent than it would be with ordinary personal information. So the default rule is where you can obtain consent to process special personal information. There are exceptions. For example, if the data subject made the information public, or you're exercising rights or giving effect to an obligation under law, but they're few and far between, and certainly you can't rely on legitimate interests without anything else. Now, I said we get three types of personal information. It was ordinary personal information. Our first red flag was special personal information. And then we get our third type of information, which is basically personal information on steroids. And that is information of children, kids under 18. When we deal with their information, general rule of thumb, don't touch it without consent from a competent person. Competent person, parent, or guardian. So, of course, there are exceptions. This is the law, and there are always exceptions, but be very careful when you process information of children and special personal information. And also when you do a risk analysis, if a cyber attack had to occur or a data breach had to occur, certainly information relating to children or your red flag information would be higher risk information than your ordinary personal information as a general rule. Of course, identifying numbers such as ID numbers would also be seen as high-risk information when it comes to a cyber attack. Now, defending a breach security compromises in terms of POPIA. Section 22 of POPIA is very harsh. Section 22 says if there are reasonable grounds to believe that personal information has been accessed or disclosed to an unauthorized person, then you must, as soon as possible, tell the regulator and tell the data subject. So we must do it as soon as possible, and our breach notification is a comprehensive one. The Act is very prescriptive as to what we should include in our breach notifications. We don't have a threshold. So for example, under the GDPR, you only have to report breaches if there's a likelihood that it's going to cause substantial harm to human beings. POPIA doesn't have such a threshold. Small breaches, taking somebody else's printing accidentally, is treated on par with a massive cyber attack if you read Section 22 in isolation. Quite interestingly enough, POPIA doesn't define a data breach. In fact, the right language for data breach is probably a security compromise in terms of POPIA. The GDPR does define a data breach, and if you haven't noticed, the definition in the GDPR goes wider than what a security compromise in terms of POPIA would be, because it also addresses things such as loss of data. Now, very important things to take into consideration as far as data breaches are concerned is to document your findings. Wow, what went wrong? Learn from your mistakes. Take steps to prevent this from occurring again in future. And in fact, POPIA says we need to address our security measures should address our risks, which we have identified, and we should tweak our security measures if we find that they don't address our risks. Do consider taking out cyber insurance. Don't only react to cyber events, plan for them. They are very likely to happen to your organization. And don't get so bogged down with the actual breach that you forget to notify the regulator and your data subjects. Crucial to have an incident response plan. The incident response plan should be tailored to your organization. Key aspects to include in it is the names and after hours contact details of the team that should address and deal with an incident. So very often, most often, the cyber attackers don't keep office hours. So make sure you've got after hours contact details. You must be able to evaluate risks, have containment measures to mitigate the risk, remediation steps, and surely it's very important to understand your notification requirements, which I have already mentioned. So moving on to a data breach reporting decision tree. Now, in terms of POPIA, as I've mentioned to you, just about every single thing must be reported. And it was very difficult drafting this tree, but we try to look at exceptions as to when a data breach or security compromise would not have to be reported. The first step would be to check if data has been compromised. Of course, has something gone wrong with data? Now, a lot of things can go wrong with data that would not necessarily be reportable. For example, personal information could be damaged, it could be destroyed, it could be lost. Think of a laptop falling into the ocean because you're working after hours on your holiday. So very often data could be compromised, but it's not necessarily reportable. So your first question is, have we seen a data compromise? Your second question is, if we have seen compromised data, does the compromised data include personal information as defined in POPIA? Now, of course, when we come to personal information, we have to remember it is information relating to living human beings and to existing juristic persons. So if your supplier information, for example, was compromised, remember that would be personal information in terms of POPIA. Your step 3 is, if we know data was compromised, we know it contained personal information, to whom did that personal information relate? did that personal information relate to the organization itself? Was it, for example, your own financial statements, your own internal policies, or did it relate to a data subject, such as an employee, a customer, and a supplier? It is only data breaches relating to personal information of data subjects that you would have to report. The next question for consideration is, are there reasonable grounds to believe that the data was accessed or disclosed to an unauthorized person? So accessed by an unauthorized person or disclosed to an unauthorized person. And here we can make out a good argument that you need some evidence to base your reasonable grounds on. It's not just a thumbsuck. It could, for example, be forensic evidence, data logs showing that data has been exfiltrated. So you would have to have some sort of evidence to show that there are reasonable grounds to believe that the actual personal information was compromised. In step 5, you check whether this was permitted disclosures or permitted access. So was the person to whom the information was accidentally disclosed, or the person who accidentally acquired the information, were they permitted to have access to the information? And this could, for example, be an internal email that I meant to send to one of my colleagues. I send it to Raki, but it doesn't matter that Raki saw the email because she was also a permitted person to see that email. The next step is, if the data was accessed by a third party who was not permitted to access it, was that third party an employee or somebody completely different? Now, let's say an employee violated access policies. So an employee violated access policies or got hold of data that they were not authorized to have data, that they were not authorized to have access to. Would it necessarily be a reportable breach? Well, if you read Elizabeth de Stadler's book on Overthinking the Protection of Personal Information Act, she seems to be of the view that a breach of access policies would not necessarily result in a reportable data breach. Whether the information regulator agrees with the stance is a different story, but I would suggest that where it is an employee, you perhaps take into consideration using a risk matrix whether high risk or low risk data was compromised. If the data was exposed to or accessed by a third party, was not authorized to have that data, then in all likelihood, you would be obliged to report this data breach. But of course, this also covers where data was accidentally disclosed to somebody who wasn't supposed to get hold of that data. Think, for example, of an email that I sent to the incorrect recipient. So we're not necessarily talking about a cyber attack or data theft here. It could also be my mistake in accidentally disclosing data to an unauthorized third party. In step 7, we check. Now we know that we have disclosed this data, or this data has been accessed by a third party. Our next step is to check whether that person has in fact accessed that data. And think, for example, of an email.
Apologies, everyone. I think we've Ira's having some connectivity issues at the moment. So I'll just perhaps take over for her here. So I'll do my best to be able to take you through the portions that Ira is going to do. I mean, she is the queen when it comes to these aspects. But essentially, what she was talking to about here is the fact that, did the third party in fact access or receive the personal information? And here we're looking at whether or not that compromised data was opened. So if the email is accidentally sent to an unauthorized third party, you should perhaps immediately contact that person, ask them whether or not they opened it, ask them to then delete it, and probably keep some kind of record, with the information officer to make sure that, you have recorded the steps that you've taken to try and mitigate any harm that could have arose from that accidental opening of that email or information. In step 8, we want to look at when did the security compromise happen. So POPIA only comes, into effect from 1 July 2021. And there was a grace period of 12 months before that, of 1 July 2020 to the end of June 2021. So it's quite tricky to actually navigate those periods. There was a lot of debate about whether you were supposed to report data breaches during the grace period. Many people did, some people didn't. The information regulator encouraged the reporting of those incidents, but it wasn't necessarily required. So, you do want to consider that as well. Other than that, you would also want to determine whether it perhaps was before POPIA, came into force and effect, even before the grace period, because then the law wasn't enforced and there wouldn't have been an obligation. So, it is important to pinpoint when exactly the compromise took place. Further to that, you are required to then, at step 9, report that security compromise. So now that you've determined that there is a security compromise event, you are required to report that to the information regulator and data subjects as soon as reasonably possible. I see Ira's back, so I'm going to stop there to allow her to complete that part. Ira, I'll continue to share for you, but you're welcome to go ahead.
Thank you so much, Rocky, for so professionally taking over. I am on backup Wi-Fi due to a power failure, but I'm sure we've all been there and we all understand. So yes, Rocky was discussing whether the breach happened before the commencement date. Did it happen in the grace period? Did it happen after POPIA became effective on 1 July? After that, step 9 is that very difficult thing of now reporting. So now you have to report the security compromise to the information regulator and to our affected data subjects. There are some instances where we don't have the data subjects, for example, where we don't have their contact details anymore, or if a public body such as the South African Police tell us not to notify the data subjects because it could affect their investigation. And then finally, the last thing that we would consider on our data breach decision tree is whether we should take criminal or civil action against the perpetrator. So was this a data theft? Did we accidentally disclose the data? Was it our mistake? Or was this a cybercrime? So we would take into consideration our common law theft, and we would take into consideration the new Cybercrimes Act. And as you know, in terms of the Cybercrimes Act, when the relevant provision comes into force, financial institutions would have to notify the South African Police Services of certain cybercrimes. And at that point, I hand back to you, Rocky. Thank you so much for manning my slides.
Not a problem. Thanks, Ira. Yes, so we're moving on to the Cybercrimes Act. So the Cybercrimes Act actually, was passed into law in 2020, but we were awaiting, the full commencement of the act. We actually only have, I would say, partial but majority of the provisions which came into force on the 1st of December last year. And since then, we've all been trying to get to grips with the legislation to understand how it impacts our businesses and what we need to appreciate of the Cybercrimes Act in order to put in place the right governance processes. I'm not going to go into too much detail on the Act itself. It's actually a very well-written piece of law in that it really does explain each of the cybercrimes quite clearly. Obviously, until we have to grapple with the law and try and determine if something is a cybercrime. But for the moment, it is quite, easy reading. Interestingly, when the Cybercrimes Act was first published as a bill, it was published as the Cybercrimes and Cybersecurity Bill. And as you can imagine, Parliament really grappled with the cybersecurity aspects of it and trying to decide how to actually regulate those. And none of the other jurisdictions around the world really talk about, specific legal cybersecurity measures that you have to take. So they took the decision to drop that element of the Act, and so we only have the Cybercrimes Act. Cybercrimes Act firstly codifies the cybercrimes. Up until this piece of law, we've had the Electronic Communications and Transactions Act, or ECTA, and it provided for very high-level codification of cybercrimes, but not many people actually were aware of it or were able to actually use that law to deal with the cybercrimes that they were facing. So this law really brings everything together. As you can see, there are various chapters that deal with things like, jurisdictional issues. As you might be aware, cybercrimes span multiple jurisdictions. You could have cybercriminals sitting anywhere in the world, and we have to create, the ability for our law enforcement agencies, for our courts to be able to deal with these crimes that occur and affect South African citizens. So Chapter 3 deals with those jurisdictional issues. The Act also provides for how, law enforcement agencies can cooperate with other jurisdictions in order to enable, the prosecution of these offenses that do occur either in South Africa or elsewhere in the world, but that affect South Africans. So it's a really all-encompassing piece of law. So as I mentioned, from 1st December 2021, most of the provisions of the Cybercrimes Act came into force with some exclusions. So on these two slides, it showcases the particular sections that are not in force and those that are. So, Chapter 1, the definitions and interpretation section came into force. Chapter 2, most of which deals with the codification of the cybercrimes, did come into force, except for a specific provision, which is Part 6, apologies, which deals with orders that can be granted to protect complainants from the harmful effect of malicious communications. That section, for example, is not yet in force. Skipping a little bit ahead, Chapter 8, which provides for the reporting obligations and capacity building, of those agencies that are going to deal with the Cybercrimes Act. That particular section is not yet in force, and then there's some additional sections that are not yet in force. So what is the crux of it? The crux of it are these provisions, Section 2 till about Section 16, which are the actual cybercrimes. Importantly, something will only be a cybercrime if, firstly, the two elements are proven, and that is the unlawfulness of the act or omission and the intention to have committed that act or omission. So you look at whether or not the actual cybercrime exists. So unlawfulness refers to an unjustifiable action in law. So if you commit a murder, that is unlawful because there is a law that says you cannot do that. However, if you committed a murder in self-defense, then perhaps that wasn't an unlawful action because you had a justifiable reason for committing that act. You must also then have the intention. So this is about understanding the unlawfulness of your actions, or at least foreseeing that unlawfulness, and regardless of knowing that, you still proceed with that course of action. So this is, for example, where you set fire to a building and there's people inside that building and that there's the possibility that they are going to be harmed, and you still proceed to do that. You had the intention to cause harm in those instances. So once you've gotten over the hurdle of, proving the unlawfulness and the intention behind it, we then look to the specific cybercrimes. As I mentioned, they're quite clear. It talks about either the interception of data, performing certain acts in respect of software or hardware tools, interfering with data or computer programs, or interfering with storage mediums, or unlawfully accessing information or passwords or codes or data. Further to that, there are these more specific cybercrimes like cyber fraud. This is where you intentionally create something that's not correct, and you try and pass it off to someone else. So, for example, you're creating dummy banking profiles. Cyber forgery, this is where you unlawfully make something with the intention to defraud. So you create some kind of document to try and deceive people into believing what your view or something. Uttering speaks to, where it could be a forgery, but you would actually speak to it. So there's that verbal communication of that forgery. Cyber extortion is essentially your blackmailing situations. Aggravated offenses are those where, it includes any kind of restricted computer system. This relates to infrastructure that is either of a financial institution or of an organ of state. Those offenses will, so if you commit any of the cyber crimes, but it relates to perhaps, infrastructure of a bank, that will be considered an aggravated offense and attract a higher penalty. And then the last thing is around theft of incorporeal properties. So currently the common law definition, doesn't extend to incorporeal property, but now through the Cybercrimes Act, that is now the case. The next section of cybercrimes under the Cybercrimes Act speaks to malicious communications. This is important to prove the element of disclosure. So you must have communicated this message that intends harm, threatens harm, incites damage to property, or even the sharing of an intimate image. So for example, if you think back to the riots that occurred last year in Durban, and people were on social media and inciting harm and damage to property, those people could technically have been charged under the Cybercrimes Act, but unfortunately it wasn't yet law. The Cybercrimes Act does have an intersection with POPIA, as you can imagine. And so what it does actually create is that if there is, for purposes of Section 2, which deals with unlawfully accessing information, data, storage mediums, computer programs, Section 3, which talks about unlawful interception of data specifically, and Section 7, which deals with unlawfully possessing, provisioning, receiving, or using passwords, access codes, or similar data or devices, then if you've committed any of those acts and any failure by a responsible party in relation to those leads to, Chapter 372, which is transporter transfers or provisions of a code of conduct, then POPIA will actually apply. So because it recognizes that there is this overlap between these two pieces of law, it does provide that in these instances, POPIA will trump the Cybercrimes Act. Some of the penalties that criminals can face under this law is they could face jail time from anything from 1 year to 15 years, as well as a fine or both, depending on the cybercrime that has been committed. It also creates the ability for cyber victims to obtain protection orders in respect of certain cyber crimes. Before this, you would have to go to under the, I think it's the Harassment Act. It is a very long name, but you would have to try and get a protection order from there. So the Cybercrimes Act creates this provision that enables you to get a protection order against your cyber attacker. Lastly, but also importantly, firstly, this provision is currently not yet enforced. This is one of the suspended provisions, but there are obligations on electronic communication service providers and financial institutions to, without undue delay and where feasible, not later than 72 hours of becoming aware of an offense, report such offense to the police and preserve such information as they may have in order to assist the law enforcement agencies. And a failure by these parties to do so can lead to a fine not exceeding 50,000 rand. So further to, when you going through the decision tree, as Ira mentioned about, a cyber attack that or cybercrime that you may be facing, you must also remember that there might be an obligation under the Cybercrimes Act, depending on the entity that you are, to report this to the police as well. So linking all of these risks that we've now highlighted under, the Cybercrimes Act, under POPIA, what is effective cyber governance and how do we go about implementing that? So first, you want to look at some of the cybersecurity measures that you can take. You want to always start with understanding what does your current infrastructure system, internal, policy landscape look like? And the only way you're going to be able to do that is through some kind of security audit, a security compromise assessment and understanding, where are the gaps, reviewing your policies, and then actually looking at whether or not you want to, perhaps hire third-party managed security service providers to also do these assessments for you. And then obviously recommend the appropriate mechanism to mitigate those risks that have been identified. So at the beginning of the session, I highlighted the fact that, we've all been working from home, which has increased the cyber risks that all organizations face. And, it's a really good time for us in considering, your cyber governance processes to ask yourself a few of these questions. So Is your VPN working like it should? Are employees able to connect from home in a way that is secure and in a way that doesn't compromise the rest of your systems? What vulnerabilities or gaps do I have in my remote infrastructure? And do people have higher level privileges still needed now that they're working from home? Or could their access be more easily monitored or reduced? So you might want to consider those elements to help you manage your cyber risks. Further to that, cyber governance also speaks to discussing these issues and raising and reporting on them at a board level. So does your board actually receive regular reports on the status of your company's cybersecurity governance? If not, why? Because they definitely should be. And if you are doing it, what is the practice? How often are you actually reporting on this? Is it on an annual basis, which is probably not enough? Or is it, more regularly? Have you identified your key information assets in your organization and assessed their vulnerability to attack? Has responsibility for cyber risk been allocated appropriately? Is it on the risk register that you have in your organization? Do you have effective risk governance structures that your risk tolerance and controls can be aligned with? Do you have an appropriate information risk policies and adequate cyber insurance? All of these questions need to be considered when assessing your internal cyber governance processes. An organization's board is certainly and most definitely responsible, to shareholders, regulators, customers, clients, service providers for the framework of standards, processes, and activities that secure the organization against cyber risk. So all boards should be aware of their cyber threat landscape and understand what advanced persistent threats are, and keep up to date so as to ensure that you are always protecting yourself and your organization against all of these cyber risks. As with everything, there are challenges to implementing a good cyber governance program. These include trying to define the strategy and your goals. And as part of that, you do want to look at, this ESG component as helping to substantiate and placing the right priority and importance of cyber risk and cyber governance management. You want to put in place, the appropriate standards and processes, but there are so many out there. So how do you determine what that is? There's some really great international standards around managing cyber risk, such as the ISO standards or the ISAE standards, and many organizations subscribe to those as a benchmark of trying to determine, whether they're measuring up to international best practices or not. The other challenges are enforcement and accountability. In South Africa, we have great pieces of law, but we sometimes face challenges with trying to implement it and enforce it correctly. So I'm sure it will be the same with the Cybercrimes Act, but yeah, that is something that we will have to overcome. Some of the other challenges are, having that senior leadership oversight and getting your board to take these issues seriously. I know they are becoming more aware that it is a concern, but a few years ago, many people really struggled with trying to get the board to understand how serious these risks can be. And lastly, having resources. That's always a challenge coming out of the pandemic. Everyone is really, in a really difficult position. So applying time to these projects and even, actual money to be allocated in having the right budgets to put in place to tackle these risks can be a challenge. So the elements that make up good cyber governance include having the right controls and certifications in place, having business continuity and disaster recovery plans in place so that you know what to do if you are facing, for example, a ransomware attack. Having the laws and regulations, obviously that's out of your control, but that is now in place. Implementing good cybersecurity, auditing and assessing whether these security measures that you've put in place are actually effective, and then implementing also a very good incident response plan so that everyone knows what to do, and dress rehearsing these plans so that you're not all standing like facing like a deer in headlights where you have no idea where to go and you're scrambling and panicking. So you do want to actually practice these response plans. I'll just touch on very briefly these other elements that goes into putting in place the right cyber governance. So, technical and organizational measures speak to various types of elements listed on the screen, like risk management, asset management, data security, and security monitoring. And these words, as it seems familiar because it would have been taken from POPIA, because POPIA talks about having the technical and organizational measures in place that are both appropriate and reasonable. How do we determine what that is? There's no one-size-fits-all solution to information security. There's a lot of factors that go into determining what is appropriate and what is reasonable in your position. So, you do want to consider that. And also, it's so important to conduct your privacy impact assessment so that you are actually aware of the gaps. Speaking to the, personal information or privacy impact assessments, you then want to do your other internal assessments of your IT systems, third-party procurement processes. How are you retaining data? How much training are you giving your staff? Are they aware of your policies that you've now put in place after POPIA? Have you actually trained them on these policies so that they are aware of it? All of those goes into putting in place a good cyber governance framework. There are also various policies that really go towards making sure that you're putting in place the right controls and you're really fostering a culture of cybersecurity and data privacy compliance. This is just a really interesting slide and speaks so nicely to the start where Ira spoke about the Ashley Madison case. I mean, this infograph really shows you how easy it can be with the technology that's available to cyber criminals these days to hack your passwords. It really does help you, determine what's appropriate as a password policy and to manage this going forward. So just in terms of some closing remarks, we hear about, ESG, but particularly around managing your cyber risks in this ESG framework. And, cybersecurity is really only one aspect of measuring a company's ESG. While good cybersecurity practice can lead to satisfying some of the elements, it can't be obviously considered in isolation. There's a lot more that goes into ESG than just cybersecurity, but it does help to bolster some of these elements. So, obviously under the G element, but there is some of the S elements. So under social, there is an increased focus and awareness on good data practices, good cybersecurity practices, and protecting data and managing information is really translating into customer trust. And a good cybersecurity framework goes a long way in improving a company's social metrics, building your brand and your reputation with your customers and your service providers alike. On the G component, reporting on cybersecurity practices allows investors to have good understanding of a company's general corporate behavior, and it also demonstrates a more holistic view of a company's operational capabilities and its resilience, which are some of the things that people would consider when looking at, how you govern your organization. And so to wrap up, I'd like to leave you with this last thought. Digital risk, including cyber risk, is a pervasive and potentially existential concern, and leaders need to understand and take account of cyber risk in their strategic decisions. It's no longer an IT problem. It's no longer a compliance problem. It really is a board problem, and it is very important. So, Ira, I don't know if you have any last remarks, or if there are any questions.
Yes, Rocky, I do. While you were discussing governance, I was also just thinking just to tie it back to POPI. And if we look at the conditions of lawful processing in POPI, those 8 conditions, the heart of POPI sitting in Chapter 3, we should be tying this back to condition 1, which is accountability. And we should also be tying it back to security safeguards, which you have mentioned. Now, as far as accountability is concerned, and of course, we must always comply with all 8 conditions, but let's just focus on these 2 in the last 5 minutes that we have. As far as accountability is concerned, we must comply with POPI, and we must be able to show we comply with POPI. How do we show compliance with POPI? And that is where those policies you were talking to, Rocky, become so incredibly important. So we have to have a data protection policy. We have to also, aside from policies, we have to have an information officer who is registered with the information regulator. So If you don't register somebody or you don't appoint somebody, it is automatically your CEO. And the CEO must then register or appoint somebody to become the information officer. I spoke to a data protection policy. We must have a compliance framework, which is not defined. What is a compliance framework? You can have a Beetle or Rolls Royce. It is not defined, but you must have a framework setting out how you are going to implement POPI in your environment. You have to have procedures dealing with data subject access requests. What I see in practice is that a lot of our clients fail to distinguish between a PIA request, a Promotion of Access to Information Act request, where you're requesting a record that can pertain to a third party, and requests for accessing your own information. You might have beautiful policies that are drafted perfectly, but your staff haven't been trained on how to distinguish between the two, how to recognize one. They fall for phishing attacks because we haven't done proper training. So a last area that I want to highlight as far as accountability is concerned is training. We mustn't think that we've done POPI training, we tick the boxes and it's over now. It's an ongoing requirement, certainly for new staff at induction. And I would certainly recommend POPI training at least once a year for your staff. They really do forget what you have told them. And then just lastly, tying your discussion back to processing condition 7, remember we have to identify the risks that we are trying to mitigate. We have to implement organizational, your common sense measures, technical measures to address the risk. And don't forget to address remote working. Back to you on that, Rocky, but you've identified that remote working is a supreme risk when it comes to security measures. Make sure that your risk identification measures, your action plan, your gap analysis does speak to remote working if you are still allowing that or if you've got a hybrid environment. And that is it from me, Rocky. I'm handing back to you.
Yeah, thank you so much, Ira. Yeah, maybe as a last point, I think many organizations really rush to put in place cyber governance frameworks, cybersecurity policies, remote working policies, because we all were just pushed into this pandemic and everyone was forced to work from home. Similarly, we were all in very difficult positions and POPIA was sprung upon us and we rushed to put in place, compliance frameworks and data processing activities and deal with all of that. And I think now that we, coming up to that anniversary of, or the birthday of POPIA, it's a good time to do these health checks, if you would, where you can sort of assess, have the measures you put in place actually being practical? Have you been able to implement it? And are they effective? And that goes across from POPIA to cyber to anything else in compliance. I think it's always good to have that check-in on these processes, especially in these beginning phases of new pieces of law. It's so important to look back and make sure that these measures that you've taken are actually appropriate and effective. So I'll leave you with that. I see there's no questions, so I'm guessing we've answered it all in the presentation today. But if you do have any questions that may come up after you are mulling over these thoughts, please feel free to email both Ira and I, and we'd be happy to answer any of your questions. And thank you so much for joining us. Have a good rest of your day.